So, Mr. Gosnell, we gave you more than 25 minutes. So you are ultra prepared now. Keep it to the barest minimum possible, because what we wouldn't like to see is a ping pong exercise. We are experienced enough to know what to distinguish between the wheat and the chaff, and what's regular and what's not. So, go ahead.
Thank you very much, Mr. President. I appreciate your comment, and I will do my best to be of assistance, although I may not be able to be as detailed as I would like to be. But I'd like to start, first of all, with the issue of detonations. Now, the argument that you've now heard from the prosecution is that detonations at approximately between 5 and 5:20 proves that there was a massacre going on at that time. I point out to you first that this is not an argument that is systematically made in the brief. It's come up only now, at this late stage. But nevertheless, let me address it. And there are, I suggest to you, two issues. One, are the detonations going on at that time, during that first shooting incident? And secondly, are any audible detonations actually coming from the Kravitsa warehouse? Prosecution started by saying, relies principally on Čelić's testimony. And after describing that testimony said, Čelić is not great on time. And let's remember, Your Honors, that it's not disputed that there were grenades being thrown later in time. But that's not the issue. The issue here is whether or not grenades are being used at that time, and whether or not that indicates that there's a massacre ongoing at that moment. And let's remember that not only is Čelić not great on time, the testimony is that he is 600 to 1,000 meters away. We do have two witnesses who were right there at the time, however. We have Đukanović. And here's what Đukanović says on this subject at page 11768, lines 13 to 19. All right, approximately, best that you can remember, how long did that shooting last? Answer, well, maybe 10, 15 minutes, but not throughout, not all the time. Besides the shooting, what else did you hear? Did you hear any other loud noises? Answer, I heard noises, explosions, but that was already towards dusk. But I didn't go anywhere near. Now, to be frank with Your Honors, when you read this gentleman's testimony in its entirety, you will see that there are many problems with time, and even problems with the day. But nonetheless, when you look at this sentence, I suggest to you that he's trying to convey that those grenades were actually being detonated later on that evening. And that is consistent with what we have told you. Witness 111. What does he say about this? And I apologize for having to go through a lengthy quotation, but it is important, and he is a credible witness. He's in the middle of an answer, and this is at the top of page 6995. Then, after a certain amount of time, I don't know how long, they just changed their behavior, referring to the guards. Suddenly they became angry. I thought that something was going to change, but I didn't know what was going to happen. What their opinion was, I don't know. At one point, though, they became angry. Question, okay, and after they had become angry for some reason, is that when the shooting started? Answer, the shooting began after they became angry, and the shooting went on for about half an hour, perhaps. Can you describe the caliber of weapons you heard being fired? What kind of weapons you heard? Answer, automatic weapons, an 84. I could see which soldiers had the 84s in their hands. Automatic rifles, machine guns. Then down on the next page, 6996, the questioning follows up on these answers. So, when this shooting started, could you hear automatic rifle fire and this 84 rifle fire or 84 machine gun fire? Answer, yes, of course. Automatic rifles too. Machine gun and automatic rifle have the same sound almost. The 84 has a slightly different sound. I even heard a tank firing, an anti-aircraft, 23 millimeter weapon, a Praga, and you could hear loud detonations of grenades. The detonations were so powerful that I was able to hear. And you say this went on for about how long? About half an hour approximately. I don't know exactly. Now, Your Honors, I suggest that you can read that passage in draw two reasonable inferences from that passage. One reasonable inference is that there was shooting in the warehouse at that time. He's talking about the first shooting incident in this answer. And secondly, what he's testifying to, what he's saying here, when you look at the words carefully, is that he's hearing detonations and artillery fire going on somewhere else. That's the implication of this, because we know that there's no tank sitting in the Kravitsa warehouse compound. We know there's no artillery piece there. He's describing fire going on somewhere else, and that includes detonations of grenades. And there's other evidence that supports that. 156, whose testimony we generally would not say is reliable, says, and who is relied on heavily by the prosecution, says that when he enters the warehouse, as he is entering the warehouse, he hears constant gunfire going on in the hills around him. That's what he says. Prosecution said this morning, no, there was no combat going on anywhere else, except at the Kravitsa warehouse. That's the only place where shooting was going on. That's the only place where detonations could have been heard from. That's not true according to 156, their star witness. And I would also commend you to the trial video. And if you watch it over the minutes during which Popović is in and along the road, you can hear periodically gunfire and detonations. So the suggestion that if you hear a detonation, it must be coming from the Kravitsa warehouse is completely fallacious. And that was the point that we were making in our closing remarks. I'm grateful to my friend for having corrected the reference to Popović. It's true, notwithstanding what is said in their closing brief, there is no reference in Popović's testimony to the sound of grenades at the warehouse. So there you have three witnesses, two of whom are right there on the scene, much closer than Čelić, much better in terms of time, and they don't hear these grenades. Second argument. Why are the two guys there if they're not guarding these individuals, these prisoners? And they say, well, the prosecution, or the defense, the defense only has Popović. That's all they have to rely on. And I suppose I just misspoke, Your Honors, because during the discourse, I did start to feel as if I was the prosecutor and the prosecution had become the defense, because I did feel that the burden of proof had been reversed. And it's not just Popović. It's Nesković, who we rely on at paragraph 191 of our brief. Because the issue here isn't just, do we have some specific evidence on the record explaining why these two gentlemen might have been off on a frolic of their own. You can understand, Your Honors, why there might not be evidence that's that specific as to why these two guys went off on their own. But look at the broader context of this case and the evidence that you've heard. And the broader context of this case, I suggest, is that there is an abundance of evidence of soldiers occasionally wandering off and doing their own thing. That is a reasonable possibility. And Nesković simply articulates one witness's view of that happening and why it might happen. And I suggest the prosecution simply has not excluded that as a reasonable possibility because, Your Honors, there's a broader context. If there were no other units in that area, maybe you could draw that inference. But you have our brief, and you know that there were other units in the area. You know that there were two commanders from the Bratunats Brigade in that warehouse compound at that time. Third point, and this may not be of any great importance, but nonetheless I feel that I have to mention it. The prosecution said, Stupar gets there almost immediately. Where's the evidence of this, Your Honors? There's simply no evidence to support that assertion. And we say that it's actually much more reasonable that Stupar goes there and that upon arriving, as soon as he arrives, he then, once he sees the injured comrade, that is when he gets on the Motorola, and that's when he calls up the road. There's absolutely nothing that suggests otherwise in the evidence. Fourth, detonations over the Motorola. The prosecution is hypothesizing, I suggest to you, flagrantly speculating that what Borovchanin hears over his is, sorry, let me rephrase that, that what Borovchanin is saying he heard is that he heard detonations on his Motorola that came from Stupar's radio, who was at the warehouse while these detonations were going off. That's the chain of reasoning that they're presenting to you. I suggest that that chain of reasoning collapses on at least one obvious ground, namely that there were other Motorola's floating around at that time in other places along that road, and that there were detonations of all kinds audible along that road, not least artillery fire from two artillery pieces that are actually along the road. I think in that context, it is beyond unreasonable to try to make the inference that what he's hearing or saying he heard is detonations at the Kravitsa warehouse. Fifth, hearsay evidence. Your Honors, we discussed this in our brief. This is one of the few cases where you can look at this hearsay evidence and you know exactly why it's not reliable. You can see the telephone tag that's going on between these individuals. You have the testimony of Peretz Vasevic, who explains his misunderstanding about who was there when he was at the warehouse, and the inference that he wrongly drew. You can see it unfolding in the testimony itself. And for the prosecution to put weight on PW 168's testimony for the reasons that we express in our brief, I suggest is completely unreasonable. Fifth, or perhaps sixth, to Zvornik instead of towards Zvornik. We never suggested in our closing remarks that Mr. Borovchanin never said to Zvornik. That wasn't the point. The point was that there were other occasions, on some occasions he does say towards Zvornik. The issue here essentially is whether Borovchanin was being truthful in asserting that Mladic, in the early afternoon of the 12th, told him, "You're going to Zvornik." Now, you remember the testimony of Richard Butler, indicating that the VRS did not know exactly where the column was at that time. It is plausible, I assert, that Mladic would have said, "You're going to Zvornik." It is plausible that Mr. Borovchanin actually remembered that, notwithstanding the fact that he then deployed along the road, and that he accurately, with scrupulous honesty, even though it's an inconvenient fact, that true, it doesn't seem completely sensible to say it, but nonetheless, out of scrupulous honesty, he says, "Yes, I was told to go to Zvornik. No, I didn't end up there." Seventh, and perhaps I should just go back to this to and towards Zvornik point. Look at how much reliance the prosecution places on that point in their brief. And when you realize that that is an unreasonable attack on Mr. Borovchanin's honesty during the interview, I suggest that that should alter entirely your view as to how honest he actually was during that interview. Seventh, you were treated to a list of concessions, I put in quotation marks, that were made in our brief about when Borovchanin's men did have custody along the road, and custody in part at Sandichi Meadow at times. We do make those concessions. But notice how the prosecution just tries to paper over all of the important issues that are fundamental to this case. Namely, how do the prisoners get from Sandichi Meadow down to the warehouse? Who escorted them? What is Momir Nikolich's role? Who is guarding them at the warehouse? What's the evidence on that? All of this just gets papered over into an overly dramatized submission at the end of the case saying, well, look, they're kind of generally up there. They're generally in that area. They must generally have moved by osmosis down to the warehouse. That's not reasonable, Your Honors. That is not proving your case beyond a reasonable doubt. Eighth, you were treated to some quotations from the interview of Mr. Borovchanin by the prosecutor. Now, some of us have had the pleasure of conducting interviews through interpreters of witnesses, interviewees from another culture who use another language. Interpreters are of varying qualities. There's suspicion, there's defensiveness, there are misunderstandings, sometimes there's impatience, sometimes there is pushing for an answer that you want and being impatient with not getting the answer you want. That happens during interviews. It's human nature. And I suggest to Your Honors that to try to pick on particular words that might have been used in the transcript and say, look at this word as it's been, look at how insensitive this person must be to have used this word. You have to take into account all kinds of cultural factors, idiom, and the circumstance of the interview itself in order to make a real assessment as to whether or not you can have an insight into the accused's attitude, mental state, not only during the interview, but back at the time. And it's just all too easy to look at somebody from a different culture who might be not giving answers as quickly as you want and saying, look at how horrible and evasive this person is being. And one last point, and this is critical. The prosecution just had an opportunity to rebut what we said in our closing arguments. We say that there are critical issues that we raised in our closing arguments that put a fine point on what's in our brief. Critical issues. They haven't addressed you on any of them. They've sidestepped all of the questions that were asked during our closing arguments. They've not told you the implications of those doors actually being closed. They've provided you with no explanation about the non-disclosure. Instead, they chose to treat you to a new closing statement in which essentially they went back to the time-worn strategy of changing the subject. Well, Your Honors, I implore you to stay on subject. I implore you to look at the cases pleaded. I implore you to look at their closing brief and their closing arguments, and finally their rebuttal, and analyze its consistency, its coherence, and its trustworthiness. And I believe you'll find at the end of the day that you cannot, based on any proper standard of reasonable doubt, find Mr. Borodchanin guilty of any of the charges that have been laid against him. Thank you.
Thank you. Mr. Haynes, do I take it that you don't ask for a rejoinder, or am I wrong?
I do.
Okay, go ahead then.
I join with Mr. Gosnell in echoing the sentiment that what was promised to be a brief 15 minutes and turned into something like an hour and a quarter did not conform to anything which I understand to be a prosecution address in rebuttal. But since certain issues were raised, I will avail myself of the permission that the rules allow to rejoin them. Can I start with a submission that was made that affects, I think, both myself and Madame Favreau in the way it was addressed, namely the relevance of evidence from outside the indictment period? We have never contended that evidence from outside the indictment period is not admissible. We didn't seek to exclude it. Indeed, as you will have seen from the way in which the arguments have developed, we are accused, and we will plead guilty to introducing it in some cases. That's what the Stakic appeal judgment confirms, that evidence from outside an indictment period can be admissible if relevant. But what I sought to address yesterday in my closing arguments to you was relevant for what? And it seemed from the way in which the prosecution case was put in its final brief, there was a measure of agreement between us. We submit that episodes to which Vinko Pandurovic attested in 1993 may, in circumstances, be relevant to his credibility. But beyond that, we submit those episodes are of very limited evidential value. And we submit that really, in looking at the events of 1993, you have to go through a two-stage process. Firstly, and not insignificantly, you've got to decide what facts you find in relation to those episodes. And only then can you decide what is the proper interpretation to place upon the evidence that comes from outside the indictment period. And in this case, given the contest over certainly one or two of the episodes, it's possible that you will interpret that evidence either in favour of the prosecution or in favour of the accused, or perhaps even a mixture of the two. The interpretation of these events, as you know, is completely in issue. And we do point out that notwithstanding the vocal invitation to them I made yesterday and the opportunity they have had overnight to dig around, there is still not a word in what has been submitted to you concerning Vinko Pandurovic's behaviour in June of 1993 at Ustipraca, when he let several thousand Muslim soldiers and civilians, together with their arms and vehicles, pass under the barrels of his guns. Now that moves me nicely on to the second, as it were, legal submission, the Krajnik point, as it were. Please take the trouble to read the decision in Krajnik of the Appeals Chamber insofar as it relates to Rule 90H2. In particular, we invite your attention to paragraphs 369 to 371. The Appeals Chamber was struck by the fact, at paragraph 371, despite the apparent failure of the prosecution to comply with Rule 90H2, that the appellant nor the amicus was able to identify any single finding of fact adverse to the appellant made by the trial chamber relating to an issue which was not put to him in cross-examination. And to that extent, we wholly endorse the position. And I submit that that is wholly in line with the submissions that I made to you yesterday. Where, for example, the theory about the fuel for the 27th of September corroborating the existence of an active reburial operation on that day has not been suggested to Pandurović, you don't make a finding adverse to him. That's exactly what I submitted to you. That's exactly what the Appeals Chamber, the ratio of their decision was in the Krajnik appeal. Well, we're not going to stand on procedure if the end result is a fair one. But we do make the point that none of the issues addressed to you in oral argument yesterday, where we complained about the prosecution singularly failing to put its case to Vinko Pandurović, were contained in the indictment, were contained in the pre-trial brief, were adduced in evidence as part of the prosecution, or put to Pandurović in cross-examination. And we say, in those circumstances, not inconsistently with the Appeals Chamber decision in Krajnik, that you cannot draw inferences adverse to the accused in those circumstances. Point 3, Dragan Obrenović. I'm sure it was an omission, but remind yourself of Dragan Obrenović's guilty plea, his plea agreement, and his ancillary statement of facts. Look, if you wish, to the sentencing judgment, particular paragraph 85. Dragan Obrenović pleaded guilty under Articles 7.1 and Article 7.3. He pleaded guilty as a commander. In our final brief, we specifically addressed a whole section to the legal and evidential effect of his guilty plea and the way in which we submitted it was one of the factors which would drive you inevitably to the conclusion that you could not find Vinko Pandurović was in effective control or command of the Zvornik Brigade between the 4th and the 15th of July of 1995. We note today those submissions still go unanswered. Fourthly, the zone of responsibility. The zone of responsibility was not addressed in the prosecution brief. Not one word was set aside for the area about which we had made such an obvious contest. I'm bound to say I was in two minds yesterday whether I ought to remind the prosecution, despite the specific section in our brief about it, that they hadn't dealt with it. They had another opportunity under the rules to deal with our brief in their closing oral arguments, but still they didn't. That they deal with it here today, having had our brief, having heard our oral arguments, in an alleged argument in rebuttal. And again, you have seen not one piece of current relevant legislation suggesting that a brigade under the JNA or the VRS had a zone of responsibility which mapped out an area within which it was responsible for anything, whatever happened. You've seen no regulation. You've seen no decision of the army to support this theory. We submit that it is axiomatic that the state is responsible for territory and commanders are responsible for men. Lastly, we point this out. It was referred to in our final brief, and we're astonished that the submission appears to be made contrary to it. At T2793, Richard Butler resiled from the suggestion that such a zone of responsibility does exist. There is no evidential support for such a finding in this case. Fifthly, Trivić. Trivić was not in command of a battle group under Krivaya 95. The unit which came from the Romania Brigade was commanded by Lubo Eric. We made this perfectly plain during the course of the evidence. It's in our brief. The positions of Pandurović, Trivić, and for argument's sake, Svetozar Andrić are completely different. Yet still, the prosecution, even now, rely on an ancient report by Richard Butler from the year 2000, who considered neither the evidence of Vinko Pandurović nor, frankly, most of the evidence in this case. I'm bound to say I'm beginning to come to the point where I agree with Mr. McCloskey that we have not been in the same courtroom for the last 3 years. I begin to wonder whether at times he still thinks he's back in 2001 trying General Kirstich, where these issues, understandably, were not contested. A brief word about unity of command. It's set out again in great detail in our brief. The theory that the prosecution peddle once again comes from 2001 and Kirstich. All the evidence we have adduced and set out in argument still goes unanswered. Unity of command is not law. It's a principle. The most senior officer present being in command is law. CP 417, Articles 16 and 17, and the principle of subordination of units is law, CP 699. As to formal relinquishment, we submit, perhaps a little dramatically but justifiably, that the prosecution case on that issue is quite literally all over the place. They suggest in one part of their brief that Vinko Pandurović was appointed commander of the Zvornik Brigade on the 18th of December 1992, the date of his arrival in Zvornik, not the date of his formal appointment. They ignore the fact that he never formally relinquished command of the Visegrad Brigade. They have Dragan Obrenović's appointment in October 1992, whereas in fact he wasn't formally appointed until April 1993. They rely on formality when it suits them, not when it doesn't. As to the conversation between General Krstić and Colonel Biara at about 10 o'clock on the morning of the 15th of July, captured by the Muslim intercept operators, a document which I'll show you in due course, but which needs no further amplification. We state that it is simply a misstatement of the evidence for the prosecution to say now that no recourse could be had by either men to the resources of the Zvornik Brigade because they were all employed. They self-evidently were not all employed. Look at the evidence in this case. Where did the men come from who went to Rochevich School, who went to Kozluk, who went to Pilitsa, who went to Kula School? They came from elements of the Zvornik Brigade. That's the prosecution's case. There were men available if Krstić and Biara had wanted between them to contact somebody to use them. The whole of the 1st, 3rd and 5th battalions were unemployed. There were 5,500 men there. To say that the whole of the resource of the Zvornik Brigade was committed, and that was the reason that Biara could not ask Vinko Pandurović for resources, or that Krstić could not suggest it, nor mention that Pandurović was on his way back, is fanciful. 7th point. Dragan Obrenović's movements on the 13th and 14th of July. In his closing oral arguments the other day, Mr. McCloskey told us and you, and I think I quote fairly accurately, that he'd searched and searched for evidence as to whether Dragan Obrenović was in the Zvornik Brigade command on the 14th of July. You will note from both our brief and our closing oral arguments that we have addressed both possibilities because we acknowledge the prosecutors' and everybody's difficulties in establishing correctly and exactly his movements, perhaps from the time the prisoners arrived until he came back to the Zvornik Brigade or reappeared in the Zvornik Brigade on the 15th of July. Today, for the first time, Mr. McCloskey decided which side of the fence he was going Balkovica. They still don't, because they can't, answer the point about the intercepted radio communication between Vinko Pandurovic and Shemso Muminovic. They go on and on and on about the evidence from the Krstić trial, fastidiously ignoring the evidence in this case. I am glad to hear Mr. McCloskey at last concede that on the 16th of July, Vinko Pandurovic was not making any sort of decision based upon 40 or 50 men having died. Rather, as is reflected in his report of that day, a belief that he had lost 10 men. But what about the evidence of the intercepted communication from the day before with Muminovic that showed that prior to the loss of any men, Vinko Pandurovic was amenable to letting the whole of the column free? Word about that, but let's leave it there. I'd like really just to finish by looking at a document that featured on a number of occasions in Mr. McCloskey's submissions. It's P1179A in the English. I think we need to go down a little bit. Yeah. You probably don't need to reread this. It's the last reply by B on that page. I don't know what to do. I mean it, Curly. There are still 3,500 parcels that I have to distribute. I have no solution. What Mr. McCloskey said today at page 30, lines 11 to 12, about my client was he chose not to allow them to survive. It was his choice, not Biara's. I do wonder whether we have been in the same courtroom, and I do wonder whether the excitement of advocacy causes him to say things he can't really mean.
Thank you, Mr. Haynes. Mr. Burgon.
Thank you, Mr. President. I also have 4 issues I would like to raise in rejoinder. Mr. President, it's not because my colleague did not specifically address the case for the defense of Drago Nikolic. Drago Nikolic was addressed in 2 questions posed by the trial chamber, as well as in many issues raised by my colleague in his long speech, which did not constitute rebuttal at all. And I wish to address those 4 issues, Mr. President, very briefly.
One moment, Mr. Burgon. I need to consult with my colleagues. A second. Can you inform the trial chamber which are these 4 points you would like to address, Mr. Bourgoin? How long do you think you will need time-wise, Mr. Bourgoin?
For the 4 issues, no more than 10 minutes, Mr. President.
Okay, go ahead.
Thank you. Regarding the first...
And try to take even less time, if you can.
I will do my best, Mr. President.
I know you will.
First issue regarding Milici Hospital. In response to the question put to him by the trial chamber, the OTP, of course, maintains its allegation that Drago Nikolic would have been involved in this, in the matter of the patients from the Milici Hospital transferred to Zvornik. That does not explain, however, why the prosecution did not include anything in his brief, in his final trial brief about this issue, and that during oral arguments did not say anything either about this issue involving Drago Nikolic. However, the issue of the Milici patient hospitals was raised during oral arguments for other accused in this trial chamber, but not for Drago Nikolic. In French, we say that closing arguments is called réquisitoire. That's when the prosecution is supposed to ask for something. Well, they have not asked for anything concerning this issue. The sole evidence on the record, Mr. President, about the involvement of Drago Nikolic with the Milici patient hospital is the evidence provided by witness PW168. And you know what our position is on that. I don't need to repeat that there is no probative value can be attached to the statement of facts provided by this witness. One would expect, Mr. President, the prosecution to recognize when they fail to prove something. Obviously, they can't do that. All they can say today is that Drago Nikolic is involved because he was a security officer. This is blatantly insufficient. Just as Obrenović did in his statement of facts, the prosecution tacitly recognized that there is no evidence that Drago Nikolic was involved in this issue. They cannot say that simply on one hand it's part of the joint criminal enterprise and then they say it's foreseeable. They have to pick one or the other. They haven't picked either. Second issue, forcible transfer. The prosecution acknowledged that Drago Nikolic is charged with the forcible transfer of both the man as well as the woman, elderly, and children. But they did not respond to the question as to where is the evidence concerning the woman, the children, and the man, and the elderly. In the prosecution final trial brief, the prosecution specifically mentions that the knowledge of Drago Nikolic is based solely on information he would have received about the prisoners. One, from Popović on the night of 13 July. We have already said that this conversation never took place. Two, on the 14th, but there is no mention whatsoever of any information that Drago Nikolic would have received concerning the forcible transfer of the woman, the children, and the elderly. And there was nothing either in their oral argument. They put their money on the man, they should stick to it. We had arguments on the man, they did not respond to these arguments. OTP likes strict liability. All my colleague could say today, we have him in the man, well then we also have him in for the woman, the children, and the elderly. This is absolutely unacceptable. Third issue, if I can move in closed session, Mr. President.
Let's go into closed session, please, for a short while. Private session, yeah, sorry.
We say, Mr. President, that the general who was on the line at that point is not General Zivanovic. It was General Krstić. Again, Dragan Obrenović lied in his statement of facts. It is the only evidence you have in this regard. When the prosecution is asking you to draw inferences about two persons meeting during a conversation and say they must have been speaking about something, they should apply their own standard to the arguments that we put forward. Mr. President, that conversation between Drago Nikolic and Dragan Obrenović on the night of 13 July never took place, never existed. It is a complete fabrication with only one purpose in mind: to escape his liability. Thank you very much, Mr. President.
To 21, page 58. Yes, I take it that is all, Mr. McCloskey. You feel tempted, but you're resisting the temptation?
Yes, there's nothing in the rules, thank God, that allows me to speak.
Thank you. Thank you, sorry about that. Ms. Nikolic and Mr. Bougon, you still confirm that your client wishes to make a statement, don't you? All right, Mr. Nikolic, You're free to address the trial chamber.
Gospodine predsjedavajući,
Mr. President, honorable judges of the trial chamber, when my counsel asked me if I wished to say something at the end of the trial, it took me a lot of time to decide, because as a soldier and non-commissioned officer, I rarely had an opportunity to speak and express my emotions. It is therefore hard for me to explain how I feel today when I'm addressing you. I joined the army as a boy of 15 and spent most of my life in the army. For me, the army was like a family, and I'm proud to say that I was a member of both the JNA and the Army of Republika Srpska. To claim otherwise would go against everything I believed in all my life. As far as the war is concerned, I never wanted it to happen, because the war has never brought anything good to anyone. Also, no one I ever knew ever wanted that war. It is the politicians from all sides who decided on the war, and they pushed us into bloodshed. So many lives were lost, so much damage has been done, that nobody can ever feel good again after all that happened. The war has changed my life and the lives of many other people. In the war, I lost friends, relatives, my home, and the country in which I was born and where I lived. What happened in July 1995 destroyed everything I believed in as a soldier. I was not aware of the events of those days until I found myself in the middle of all that. For the rest of my life, I will keep asking myself whether there was something I could have done that could have changed the course of those events. In theory, there were probably a lot of things I could have done. In reality, though, things were completely different, and I was powerless to do anything. Although I was only a second lieutenant, and regardless of the fact that most people in the army disliked the security organ, I thought of myself as a professional officer, and I managed to win a certain level of respect within the brigade. I was loyal to my unit, and I respected my superiors. However, all that was taken from me after the incident with my commander. Not only was I isolated from both the commander and the chief of staff, but the commander issued explicit orders to battalion commanders and their staff not to inform me of anything. So I was completely isolated. I was unable to perform my duties as a security officer in the brigade normally, and I completely ceased to send any reports to the Corps. But I still reported to my commander daily. Despite all that, I never doubted that the brigade commander was my only commander. Anyhow, this situation has nothing to do with the events that took place in July 1995. For the last 3 years, I have been sitting in this courtroom listening to the testimony of hundreds of witnesses. I heard many true stories, but I also heard a lot of lies. I often ask myself how you will ever manage to tell the truth from the lies. I understand the fact that the chief of the staff of the brigade pleaded guilty, and that as part of that process, he was asked to provide a statement. But I cannot understand what his motive could have been to tell so many nasty and untruthful things about me. He was there, he knows what happened on July the 13th, and he knows that I knew nothing of the events until the late hours of July 14th. During the war, I did not like my enemies, but I respected them. And I often had the opportunity to help many Croats and Muslims, which is something I did naturally, without any second thought, because to me it seemed a matter of course. As a soldier, I was sociable and open towards my community and the people. I liked all people equally, without any regard for nationality or religion, and I do not feel hatred towards anyone. To say that I was aware of any plan to murder all the men of Srebrenica, or that I wished that to happen, or that I took an active part in all that, is very far from the truth. I found myself in a whirlwind of events that I was unable to change or influence in any way whatsoever. I was where I was, I did what I did, but I am far from what some witnesses said about me in this courtroom. I understand that I bear some part of the responsibility because at certain moments I was at Orahovac school on the 14th of July. But I kindly ask you to take into account my limited possibilities in relation to the events that took place. I could not have influenced them in any way. I wish to take this opportunity to express my gratitude to my defense team, people who did everything they could to present the events as accurately as possible, as well as my participation in what happened in July 95. I also want to avail myself of this opportunity to thank the people who came to testify in my defense in this trial. That is all I wanted to say. Thank you very much for allowing me to speak.
Thank you, Mr. Nikolic. Mr. Guerrero.
I think he'd like the lectern, please.
Yes.
Ne mora.
I don't need it.
Say, let's go ahead. Let's proceed.
Poštovani sude,
Mr. President, Your Honors, honorable judges, I greet everybody in and around this courtroom. In March 2005, I came to this court speedily and voluntarily. I was deeply convinced of my innocence, and I was convinced that I would be afforded a fair trial. By joining the indictment, I was put in the same place and the same with some horrendous accusations.
nemajući dokaza protiv mene,
In the absence of any proof against me, it seems that the prosecution first listed serious war crimes and subsequently tried to link me to these crimes at any cost and put me in the same bed. During the whole trial, they were writing an indictment against me. Eventually, they dropped some initial charges, but brought in some new ones, of course, without any proof, which has been proven by my defense team. Now we know that he had some very diligent helpers in this process, and we know who they are. Precisely for that reason, I would really sincerely like to thank you, the trial chamber, who have always treated me in a correct and fair manner and had understanding for my specific circumstances. Thank you again. Your Honors, at the beginning of this trial, I spoke briefly as an introductory note, and I would kindly ask you to include that, if necessary, as part of this address, because I believe that everything I said in my introductory note was proven to be true. It was proven that I never was in Srebrenica or Žepa. It is not disputable that I was in Žepa because the main staff of the VRS was in the area of Žepa throughout the war. It has also been proven that I had no contacts or any knowledge about war crimes or any kind of joint criminal enterprise. The OTP is continually pushing forward some unattainable premises. Your Honors, the prosecutor, at the beginning of his closing argument, attempted to introduce a new theory of crime, which he called a specific intent, if I understood it correctly. I would like to say that I accept this term, but only with quite an opposite meaning to it. Namely, during the entire period prior and during the war, I had a specific and clear intention to remain a man with solid humanitarian commitment and to contribute even minimally to preventing the war. Once the war started, however, I tried to contribute to putting a stop to it quickly and taking part in peace negotiations. I also tried to keep my face and clean hands during the war. I always had in mind the words of Mr. Ivo Andrić, who says that the war in the Balkans is an insane period. Interpreters note the accused is speaking too fast. We are very sorry.
Yes. In case you haven't understood, the interpreters are complaining that you are speaking too fast.
If you could start from Ivo
Treba li
Andrić.
ponoviti, izvinjavam se.
Do I have to repeat?
Izvinjavam se.
I apologize. Ivo Andrić, our Nobel Prize winner, said that in the unfortunate Balkans, a war is a period of insanity during which those who are wise shut up, those who are fools start speaking, and the thugs get rich, and the rich become poor. I also wanted to contribute as much as possible to diminishing the suffering of everyone involved in the war. I was constantly involved in various commissions and peace negotiations, and whenever possible, I advocated the cessation of hostilities and peaceful solutions. I kept repeating, and there are hundreds of evidence to that it is better to negotiate for 1,000 days than to wage war for 1 day, because there are no victims as a result of negotiations. As an educator, as an assistant for moral guidance and religion, I highlighted various examples of how a man can remain honorable during the war, because any victory without honor equals defeat. I set various quotations to the units, including from Holy Scriptures, also examples from the history of our wars and other wars, describing the humane treatment of the civilians and enemies. And I always press the point that this should be pursued by our army too. Your Honors.
Please do so.
Pa, pošto niko nije sedio kad je
Well, since nobody else was sitting down, I don't want to make a precedent.
Offering you in case you will feel more comfortable.
Poštovani predsjedniče, hvala vam.
Thank you, President. I'm going to avail myself of your offer.
Hvala. Časni sud.
Your Honors, throughout the trial, the prosecutor persisted in ascribing to me the characteristics that are totally contrary to what I am and are foreign to me as a person. He couldn't find any valuable or valid proof for that, but he nevertheless persisted. I would like to say a few words that confirm my consciousness and my behavior that have been undisputably corroborated by documents and numerous testimonies. I acted in continuity both before, during, and after the war. As a young officer and someone who was extremely in favor of brotherhood and unity, as well as an officer who has civilian education, I was appointed principal of the school called Brotherhood and Unity. It had been officially proclaimed the best school in Serbia, and I was given and decorated a medal for that. Hundreds and hundreds of young men from all over Yugoslavia, including the Muslims and the Albanians, grew up under my guidance, and they became good officers. Brotherhood and unity is not a shallow phrase. That was the main characteristic of that time, and I wish it remains the same today. This was a bridge that was connecting people, that was connecting different social strata and nations. At the time, I also wrote various scientific papers dealing with integration processes in the world. I was very much interested in the processes of integration, not disintegration. The processes of integration and not disintegration was something that we heard testimonies to in this courtroom as well. In 1991 and early 92, I believed that the JNA forces would act as a buffer to prevent any inter-ethnic conflicts. I believed that the war was avoidable, because this unnecessary and devastating war could not have bring any good to anyone. It would only bring evil and victims. And I spoke and wrote about this publicly. However, when the war in the former BNH began, I found myself in that area. Immediately upon the creation of the Army of Republika Srpska, I prepared a paper, and it was distributed to all units containing their obligation to abide by the international humanitarian law and Geneva Conventions. I kept repeating this information throughout the war on numerous occasions, and this was not propaganda as the OTP pleads. In June 1992, I already distributed this information to the units, and it has been admitted here into evidence. In this document, we reiterated how important it is to prevent any revenge against innocent civilians, to prevent looting and burning. And I quote, "These kind of acts cannot and should not be something to be done by members of our army, because that tarnishes the reputation of a Serbian soldier. We cannot tolerate any incorrect and abuses against other people simply because they are not Serbs." I also insisted in this same document that they should employ humane and friendly treatment of international organizations and the media. Your Honors, I believe that the prosecution's allegation about this being simply propaganda doesn't stand. This was my belief. I didn't publicize this for the sake of propaganda. I just wanted every soldier and every unit to have that. This was not a shallow propaganda story for the media. This proves my specific intent and intentions that I never abandoned, even in the most of difficult situations. In June 1992, when the brigade of VRS was formed, I said, among other things, the Serbs want peace. The Serbian people are not fighting against any other people, but rather against the ideology and the practice of blind anti-Serbian attitude. Anyone who knows what horrors war can bring, it's the Serbs who know. That is why their primary wish is to have peace, nothing else. But we are not going to give up on what we have. This was published in all the media. The OTP must have this, but this was never used. Further on, in the book Who's Who in Republika Srpska, an unidentified journalist cited my words as follows: the Serbian army is
The Serbian army is waging war, but we are not barbarians. We are not fighting women, children, and the elderly. Ours is a chivalrous war. Here is a copy of that document. It was probably in 94. In July 95, I sent, for the umpteenth time, one document to the Drina Corps concerning the need to abide by international humanitarian law and treat the members of the UNPROFOR fairly and decently. I could quote 100 examples like this. When I recommended to the commander of the Eastern Bosnia Corps to transfer prisoners safely to their territory, and that was done. Nobody was abused. In another time, I helped the Muslim general go for medical treatment in Belgrade. I can prove that, but there are many other examples for which I cannot document here. There is a plethora of other evidence confirming my specific intent. Throughout the war, I tried to contribute to creating conditions and a climate in which all the soldiers would understand and accept the need to abide by international humanitarian law and international law of warfare. Many witnesses confirmed that this was done here, that they were aware of it, that there had been training on this. Your Honours, at one point in time, the army of Republika Srpska had around 220,000 troops deployed in around 143 large units, thousands of battalions, companies, and squads. It's clear that I could not have been present with every unit at all times and control and inspect how regulations were honored. But I am quite sure that I performed my duties properly. Everybody knew how they were supposed to act. The duties of an officer for morale and religion were redefined and frequently misdescribed in this courtroom. It's difficult to understand them, for laymen especially. Even many officers in the VRS did not quite understand what my job was, as you could hear from the testimonies of many high-ranking officers who testified here. I have 40 years of experience. I'll give you an example. One priest has a small parish under him, whereas an archbishop has a much larger parish, figuratively speaking, thousands and thousands, and he gives them guidance how they should act in everyday life. The archbishop cannot cannot be held responsible for individual crimes unless he, the Archbishop, instigated it. In history, there are no examples indicating otherwise. In the army, the assistant commander for religion and morale is not within the chain of command. He does not issue any orders to anyone. He just sends out moral, ethical messages, what kind of conduct is desirable, what rules troops should abide by, etc. If a crime happens somewhere, he cannot be held responsible personally. He can only express regret and learn a lesson, just as not a single cardinal or archbishop was held criminally liable for any of the parishioners' acts. My job is more alike to what the priests do than what officers within the chain of command do. There were 5 Orthodox bishops in the area where I worked, and I frequently cooperated. Now some of them have taken part of my job. Your Honours, I'm not saying at all that there have not been cases of violations of international rules of warfare, but I am claiming that this was not done with my knowledge and I was never informed of it. I want to be quite clear. I quite accept and support the standards of international law, including those governing criminal liability. I have always abided by them in war, and I think I've never made a mistake. I've always said, and I still say it today, that I cannot express how sorry I am for every human life that was lost, for every person who was mistreated or who suffered unnecessarily in the past war in Bosnia and Herzegovina, both people in the Drina Valley and in the Krajina, those in Bratunac and Srebrenica, as well as those in my own town of Mrkonjić, where the largest mass grave is located, for those in Sarajevo or in Žepa, regardless of their ethnicity, religion, the color of their skin, the place where they live. All of them are my compatriots, my fellow citizens, and my neighbors. I am deeply sorry for all of them. Victims are victims, and criminals are criminals. However, the greatest crime was committed by the war itself. The merciless war, the ruthless war, and those who started it. Your Honours, throughout the trial you have seen various documents in which political party and military leaders sling mud at me and try to tarnish my honor. I don't answer all these accusations. I could speak for hours explaining why I never answered any of this. But I won't. I'll just say a few words. Throughout the war, there was disharmony and discord between the eastern and western parts of Republika Srpska, and this was frequently a topic of discussion at the Assembly of Republika Srpska. It was considered that the west of Republika Srpska is bearing all the burden of war without gaining anything. Even in the end of 94 and in 95, it became clear that the western part is about to surrender without combat, and that our resources are spent elsewhere. This destroyed the morale of our army, and our troops often told me about it. And I witnessed all of these underhand games and plans. That's why they wanted to put spokes in my wheels and disable my work. They put in motion a powerful propaganda machine against me, and they wanted to replace me by an obedient yes man. I was eventually replaced by Miroslav Deronić, an activist of the leading party. In 95, I was strongly against the engagement of the VRS in Podrinje or anywhere else in Eastern Republika Srpska for that matter. The leading people in Republika Srpska and in the army knew that. The only people who agreed with me were assistant commanders Đukić, Marić, and many other officers, as well as the Vice President Koljević. It is quite symptomatic that General Marić was in the car with me when we suffered a car crash in March 95, so we spent a long time convalescing outside the territory of Republika Srpska. Shortly afterwards, General Marić had another car accident and he succumbed to his injuries. These incidents were never properly investigated. It is quite clear that I could not participate in the elaboration of Directives 4 and 7 because I was simply not there. I saw these documents for the first time in The Hague. The prosecutor never proved otherwise. Therefore, I believe that all the attention should be given to the western part of the RS, where the army was exhausted, rather than the eastern part, which was not crucial for the outcome of the war. That's why many plans were hidden from me. Since I was unable to properly perform my duties as assistant for morale and religion, I tried to resign a couple of times, and the commander tore up my resignation, saying that this was a very hard time and I was needed. Why did I do that? Certainly not for personal material interests. I believed that it was immoral to do such things in war. I did not need promotion or position or wealth. Simply I acted in the only way in which I could save my honor, help the army and the people, and alleviate the suffering that was impending. And that's what in fact happened eventually. And only thanks to Vice President Koljević, a great intellectual and a great human being, the Dayton Accords were achieved and my hometown of Mrkonjić survived. After many testimonies and evidence about the discord among the leading people in Republika Srpska, especially in the eastern part of the territory and in Podrinje, there is no reasonable grounds for thinking that I could be in any joint criminal enterprise precisely with those people who are advocating everything that was contrary to my beliefs and who were orchestrating my personal liquidation. Mr. President, Your Honours, I always believed, and I still believe, that this court is an institution of all the member countries of the United Nations. That's why everything it does, all its documentation, is a treasure for all the countries of the world, for now and in the future. I'm sure that with the increasing integration in the world, the contents of this court's work will be a subject of interest for historians, scientists, and researchers in the entire world. In seeking unbiased solutions and learning. Your Honours, when in March 2005 I was departing for The Hague, the Prime Minister of Serbia and Vladika Grigori told me with tears in their eyes that they were aware that they were sending to The Hague an innocent man, but it was in the interests of the state. They also said there was a promise by Mrs. Del Ponte that I would be in The Hague only in the days of the trial and that I would be provisionally released whenever possible. However, the Prime Minister changed and there is no more Mrs. Del Ponte, and the prosecutor wants me to die in prison. He opposes my treatment in Serbia in spite of numerous professional opinions both here in The Hague and from Belgrade. Some of them internationally renowned medics. They are expecting me to submit a plea for clemency when I'm 105. With all these unsubstantiated charges, accusations against me, innuendo, speculation, in the conviction that lies many times repeated with stick to a man who does not have the backing of any state or institution and who has no resources for defense, I can only put my faith in justice and in God's justice. But I also believe in your professional, unbiased skills, and that is why I expect an acquittal. Anything else would be the beginning of the twilight, not only for me, who doesn't have much life ahead of me, but also for the civilizational values of humanity. Your Honours, I could say much more, but I will stop here. Thank you for allowing me to say this much. I'm sorry if my speech was not legally polished. I hope you will understand that in the past 4 and 5 years, I have not had much opportunity for public speaking. Thank you very much.
Mr. Guerrero, it's time for the break. However, we are practically finished. Could I ask for your indulgence, everyone, interpreters, technicians, staff, to overstay by about 5 to 6 minutes? We have something to say ourselves now, and then we can all go home. Yes. Okay, thank you. Now, for 3 whole years, we have traveled together, sometimes in calm, sometimes in rough waters. Today we come to the end of this long journey before we embark, as from tomorrow, on another one, which hopefully in a few months' time will see us hand down the final judgment in this case. Surely you will agree with me that this has been a long, laborious, complex, and in some respects a very difficult case. Difficult to conduct and not easy to bring to an end. There are many things that could go wrong in a simple case, let alone in one of this magnitude. But I am glad to note, and I hope again that you will agree with me, that things went fine in this case. In my opinion, completing this case in just over 3 years, considering the number of accused, the largest ever so far, the number of witnesses, and the voluminous and complicated evidence, is indeed a remarkable achievement. This is besides considering that together we succeeded in achieving this in a spirit of cooperation and in a smooth and constructive manner. Having said so, let me first and foremost say something on a very personal note. My first duty today is to thank my 3 colleagues, Judges Kwon, Prost, and Stoller. Your contribution throughout the case has been formidable, and it is only owing to your constant help and support, your experience, your patience, your advice and wisdom, and effective participation that I have managed to survive this trial. I therefore publicly thank you from the bottom of my heart. It has been an honor and a pleasure working with you, and I look forward to concluding together the mammoth task of arriving to the final judgment with encouragement and a great sense of optimism. In this case, we have had no significant disruptions from either the officers in charge of the prosecution or from any of defense counsel, or for that matter, from any of the accused. This has made it possible for this case to proceed and come to this final stage without major stress, friction, or tension. On behalf of the trial chamber, I wish to register our appreciation of this. You will recall that one vital decision we took at the very beginning of the case was to impose as little limitations as possible on any of you. It was a risk that we agreed to take, putting our trust in you. We allowed you full freedom to present your respective cases without undue interference or restrictions. Today, 3 years later, I feel confident that this experiment proved successful. So we thank you all, prosecution and defense without distinction. You have all excelled. The trial chamber is also thankful to those counsel who have, since the start of this case, either left, like Mr. Meek, Mr. Stojanovic, Ms. Condon, and Mr. Sarapa, or passed away, like Mr. Nebojša Mirkic, who we remember with sympathy. We have a list of persons the trial chamber wishes to thank. I start with the registrar. That means Mr. Hans Holthaus and his successor, Mr. John Hocking. The case was a challenge to them as well, and they came out of it with flying colors. I also wish to thank Mr. Ken Roberts, now Deputy Registrar, who over the past years looked after our staffing needs with great efficiency and in a timely fashion. A word of thanks also goes to Ms. Catherine Markey-Well for coordinating several matters for us. Thank you. We thank our women at the registry, starting with Ms. Pauline Thomas, registry officer in charge of our case. She was always there when we needed her, and she was always ready with a solution. We thank Ms. Yaiza Alvarez Reyes, who is gracing us with her presence today. She lived with us most of the case, and we thank, of course, her successor, Mr. Srđan Mujanovic. Both of you, you've been very helpful. Our thanks also to Eva Trevisan, our usher. Eva, your performance has been impeccable. Our thanks to Ms. Carleen Amirali, Deputy Head of CMSS. Sometimes we gave you headaches, but you came through it fine. Thank you. We thank CLSS for their unstinting efforts and support. As I said on previous occasions, the interpreters have one of the most difficult jobs in this tribunal. And I think you will all agree with me that in this case they have been extremely patient, forthcoming, and efficient. Ms. Maja Ruzic, your deputy, Ms. Mirjana Nikolic, and the rest of you have been simply super. Thank you. The same goes to the stenographers or recorders. You too have succeeded in keeping pace with the proceedings, and I thank you all, as your work has not always been easy. You will surely recall that several times we overstayed our sitting time, like today. We acknowledge once more that on each and every occasion, all those supporting the courtroom agreed to stay with us, making it possible to go ahead. Thank you all. The trial chamber also wishes to thank Mr. Rob Barsoni on behalf of the audio and visual unit and his team, as well as Mr. Michel Lagave and his staff in the technicians unit. The e-court section also deserves special mention, and I am sure Mr. Bassem Malayeb will convey our thanks to his staff. Together, these three teams made it possible for the case to proceed smoothly without significant hitches. Thank you. I cannot forget, of course, the VWS section. And so more than a word of thanks goes to them, and also to the persons responsible for our transcript. I understand our transcript contact was Ms. Rosalind Matias. And as far as the VWS section, apart from the head, of course, we owe a lot to Ms. Isabel Skukan. Thank you. A word of thanks also goes to Olad, chief of that section, and Officer Susan Stewart, Alma Delic, Sandy Grubic, and Mirna Dzurzulovic. The security section of the tribunal. We thank you all, and I am sure that your chief, Ms. Bonnie Atkins, will convey this message to you all that have helped things proceed smoothly and without major problems in the course of this trial. I next wish to thank our respective secretaries, Ms. Renée Seu, Ms. Barbara Gekiner, Ms. Arlette Borgdorf, and up to a year ago, Mr. Rudy Hubo. They all have worked hard indeed, staying here long hours to help us be prepared for every sitting in the most efficient manner. You've been precious, all of you. Last but not least, our staff. Our senior legal officer, John Cabin, Suzanne Malmstrom, Claudia Hofer, Audrey Fino, Nakako Onishi, Ofra Natif, who leaves the tribunal and the trial chamber this week, Nolwenn Gibber, who will be moving to another case, Ruben Karremaker, who joined us in the course of the trial, Leah Campbell, Julia Chiara, Petra Dijkstra, Nak Hee Hyun, a fellow, and interns Amitis Koyaste, Maria Elena Vignoli, Rosa Aloisi, Gregory Shannon, Mark Hoskin. I also must mention legal officers who have since left, namely Lucia Katani, Mr. Yang Song, a fellow, Tillman Blumenstock, who has since left, Mary Fan, Bakel Don Taylor, and James Bishop. I also thank the trial chamber's secretary, Lee Ann Lemstra, and her predecessor, Dubravka Polic, for their assistance. A word of thanks goes to all those interns, some 30 of them, who came and left in these 3 years. Their contribution, too, has been very helpful. Finally, I would like to thank the government of South Korea for providing us with a fellow for 2 years running. First, Mr. Song, who left recently, and now in Ms. Hyun, who will be here with us till the end of this case, and who will then move to another case after that. So, my dear colleagues, we leave you here with what we believe is a positive note. We shall meet again in a few months' time for the final judgment. Thank you.
All rise. Give the